My name is Leena Heinämäki and I work as a senior researcher in the Northern Institute for Environmental and Minority Law, Arctic Center, University of Lapland. And I have today a great pleasure to have Alexandra Xanthaki with me. Alexandra acts as a professor at Brunel Law School, UK, and she has been as a deputy head of Brunel Law School 2008 to 11 and is now also director research at the Brunel Law School. A minority and indigenous rights expert, Alexandra's work has focused on indigenous rights, minority and cultural rights. Her monograph, Indigenous Rights and United Nations Standards, Self-Determination, Culture and Land, has been reviewed in several major academic journals. It has been viewed as an impressive book, which has a thoughtful, authoritative and elegantly written analysis, is extremely well argued and makes an important contribution. In 2011, she published with Dr. Stephen Allen an academic collection on essays on the Declaration on the Rights of Indigenous Peoples, which has also become a reference source on the UNTRIP. Alexandra's link with the intergovernmental organizations include her close work with the UN Expert Mechanism for the Rights of Indigenous Peoples, her cooperation with the former UN Special Rapporteur on Indigenous Issues, the ILO study on Maori participation in the New Zealand Parliament, and her role as a human rights expert on several projects funded by the European Commission. She has also advised governments on rights of indigenous peoples and international law. And Alexandra has given several keynote speeches in an elected member of the International Law Association, Indigenous Committee, and a member of the editorial committee of the International Journal on Minority and Group Rights. So, Alexandra, you have been very actively involved for quite some time now in international standard setting processes related to the rights of indigenous peoples. So, how would you generally describe the current international atmosphere around indigenous peoples' rights discourse? Like, how well are indigenous peoples' human rights recognized by different countries in a very general level?
I think that in the last 20 years we have seen an explosion of indigenous rights, as you well know, and of course the declaration was, the adoption of the UN Declaration on the Rights of Indigenous Peoples was a huge achievement. So the declaration was adopted in 2007, and after the first few celebratory kind of years, we started working a lot on how to implement the declaration and also how to interpret the provisions of the declaration. And now gradually we're also working on how to make the declaration relevant to, or rather apply consistently with the other UN standards of human rights, but also of international law. So it's a busy time for indigenous leaders and indigenous communities, and also for scholars who work on indigenous issues. So there has been a huge advancement when it comes to indigenous rights. Unfortunately, as is the case with all human rights, the huge advancement is on paper, and it's another continuing struggle to make them in practice. And there have been successes, and gradually governments and states are aware of indigenous rights, and they're much more receptive on indigenous issues. So I am very pleasantly surprised to see how receptive governments are on free, prior and informed consent. Consultation and participation now, I think, are considered a non-controversial right for indigenous peoples. So we can see some advancements, but there are still areas that we need to work on.
Mm-hmm. Yeah. So can you give some examples of best practices, maybe, or some particular?
Yes, I'm very reluctant to define states are good states and bad states, because I think this is not helpful, and the speed on which the realization of indigenous rights is progressing relates to issues other than just the will of the state. So it has to do with the resources of the states. It has to do with a lot of other issues, other maybe, other pressing needs, etc. But I think that New Zealand is a very interesting example. A lot of things are happening in New Zealand, and there is this, and the discussion on indigenous rights has progressed a lot. And there are other states that all states need to kind of work more. Indigenous peoples are still not on an equal basis with the non-indigenous peoples everywhere in the world. I mean, their distinctiveness, in any case, the level of their distinctiveness makes them vulnerable anyway, and that's why we have this special protection that we give them. But I think, for example, Canada is another state that where progress has been made. There are still problems, but progress has been made. Mm-hmm. And I think the Nordic countries have always been very positive examples of how of the dialogue that needs to happen, of course, with tensions and with disagreements, but of the dialogue that needs to be taken place between indigenous communities and the states. So I think that these are very positive examples. And even during the elaboration of the declaration, the Nordic countries were very prominent as being open to learning more about the indigenous needs, but also trying to find ways to improve the indigenous situations.
So, can you still elaborate a bit more, like what are the major improvements that have occurred actually now during the last couple of decades, and what are still the unresolved areas regarding actualization of indigenous rights?
So I think that the major areas that I have noticed are, first of all, consultation and participation. I think there has been it's amazing how consultation and participation are now considered customary international law, and also even free, prior, and informed consent. The World Bank talks about free, prior, and informed consent of indigenous peoples, which is an excellent. With a lot of problems always, but it's an excellent advancement. And I think in general, so free, prior, and informed consent, and more generally rights of consultation and participation, I think this is where we've seen a lot of changes. I think also we've seen not huge changes, but very important changes when it comes to the relations between indigenous peoples and industries. So non-state actors. More and more non-state actors realize that it is to their benefit to take into account indigenous rights. Of course, there are a lot of violations happening still. But from 20 years ago to today, we have seen kind of this advancement, and there are discussions going on. So I think that this has been very good as well. And also I think cultural heritage, indigenous rights have helped a lot the debate on cultural heritage. So there is this mutual continuing exchange between indigenous peoples and how they perceive cultural heritage, and UNESCO and non-indigenous societies and the priorities they have when it comes to cultural heritage. And one does not see this in other, with respect to other groups so often. So you don't see this so often with respect to minorities or to other groups, so to migrants, etc. So in this respect, I think that there has been a lot of progress, and also you see again how indigenous rights have had a very positive impact on general international law. Mm-hmm. And self-determination. Self-determination was as we all know, was a hugely controversial issue. more and more Indigenous leaders and scholars and even states, talk about self-determination today. They're not. I think that once we all agreed that the monster of secession has been put to bed, unless the government is hugely unrepresentative and continuously violates human rights, I think everybody felt more comfortable, and justifiably so, to talk about the specific applications that self-determination can have for Indigenous peoples. And one of the most fantastic aspects of the Indigenous transnational movement is that they're so imaginative. So they have come up with applications of self-determination that we had not been discussed before. So, self-determination, I think they brought a new, a reconceptualization of the concept. So we have seen kind of progress there as well, how self-determination is realized. And finally, consultation and self-determination combined together have had a very good impact on Indigenous institutions. And I think this is very important. We have very positive examples from the Nordic countries and Finland, where we have the Indigenous parliaments, we have Indigenous fora specifically for Indigenous peoples that have an impact. And hopefully we will see in the future these fora becoming more prominent and more engaged in the national institutions.
Yeah. So how about then unresolved issues? Like, what are the major tensions?
Yeah, I think that every single issue I talked about as having been a success is also still an unresolved issue.
Yeah.
So I think that in these wide areas you have specific kind of big unresolved issues. So natural resources, and I think in general the big unresolved issues that we still have to do with the benefits that Indigenous communities do not get from the use of the Indigenous capital by non-Indigenous communities. And by Indigenous capital I mean the Indigenous cultural heritage, so the benefits that the Indigenous communities do not get from the from the governments and the states using Indigenous sites, etc. The benefits that Indigenous peoples do not get from the state using the natural resources of Indigenous lands. So I think that there is a lot of work that needs to be done, not just to recognize. I think maybe now several governments, of course not all governments, but some governments have recognized Indigenous institutions and heritage and lands, etc. But they still have not given the benefits that Indigenous communities should have by these different areas. So I think this is kind of an unresolved area. I think the relationship, exactly what I said, has about the industries, has a different, the other side of the coin. There are still transnational corporations that go to Indigenous lands with the governments at least tolerating them, if not actually pushing them and kind of contracting them. So let's just say, at the best of cases, tolerating them, who go to Indigenous communities and we see kind of huge violations of human rights. We still see forced displacements and relocations. So this is one issue that, the negative effects of transnational corporations on Indigenous lands and Indigenous lifestyles. I think also Indigenous environments and the management and sustainable development is kind of pretty much unresolved. And I think consultation and participation, there is a very big danger that it becomes just a tick boxing exercise. And a lot of governments, even though now they have realized that, they have to consult Indigenous peoples, they just use these processes just for tick boxing.
Mm-hmm.
So I think that's still a problem. And of course we have states where unfortunately kind of Indigenous peoples are still being even killed. We should not forget states where, in so many states where Indigenous cultures are seen as inferior, and maybe sometimes not. These are not explicitly kind of discussed, but implicitly we still see that, and we still see. Unfortunately, forced sterilizations of Indigenous women. So, there's another side, when we talk about kind of self-determination and consultation, etc., there's still another side of the Indigenous rights that we should not forget, the basic, raw kind of, rights that are still being violated in many parts of the world.
Mm-hmm. Yeah. So you are one of the very leading experts in relation to both to ILO Convention number 169 and also UN Declaration on the Rights of Indigenous Peoples. So what do you regard really as the core of these instruments? And maybe that's my first question related to this. Like,
yes.
What is really the most
I think
important?
That the core is, when it comes to the UN Declaration, it's respect of Indigenous cultures, and or rather respect of Indigenous identities. And I think this is what, in any case, this is what Indigenous leaders have been saying, during the elaboration of the declaration, that all these rights for them are primarily about respect of their identities. And when it comes to the ILO, I think that the heart of the ILO Convention is Article 6, which is about participation and consultation, control, Indigenous control over their lands and over the issues that concern them. So I think that these are the two kind of pillars on which Indigenous rights have been built on.
Mm-hmm. And is there then any additional element that the UN Declaration establishes compared to ILO Convention? Like, does it make it stronger?
Yes. As you know, kind of the main kind of issue is self-determination. So the declaration is very explicit about Indigenous self-determination, whereas the ILO Convention is not, does not refer to self-determination. But also, having said that, although it does not refer to self-determination, we should interpret the ILO Convention in the light of the UN Declaration on the Rights of Indigenous Peoples. So when it says about Indigenous control, this is very much related to self-determination. When it says about, Indigenous control of Indigenous lands, this is kind of, very much about self-determination. So this is the one kind of part that the declaration has and the ILO doesn't. The other part is cultural rights and cultural heritage. The declaration is much more explicit than the ILO Convention, and also IP, intellectual property rights. The declaration. So the declaration does go in some areas further than, or rather is more detailed and does go further than the ILO Convention. And this makes sense because the ILO Convention is a treaty, whereas the declaration is a politically binding kind of instrument. Also, the declaration is much newer, but the ILO is kind of now it's 1989. It's not that new an instrument anymore. So, and I think this is something that we have to keep in mind. States sometimes, and I wonder whether this is the same with Finland, sometimes they see the ILO 169 as quite radical or quite advanced. And we have to remember that, a lot of discussions have happened since the adoption of the ILO, and many of the provisions of the ILO are now pretty much accepted in international law and by most states. So yes, this is, just to come back to your question, I think these are the main differences. The declaration is explicit about self-determination and also about cultural heritage, also about IP rights. I think also the declaration says a bit more about natural resources, and some specific issues, for example, military activities on indigenous lands. So, the declaration is more detailed.
As you already mentioned, the declaration is not legally but only politically binding. But still, UN human rights monitoring bodies and national courts are referring to it constantly these days. So what is really the reason for this? Have some parts of the declaration become a customary international law or generally accepted principles and rights? What is your
Yes,
view?
I think first of all it's very important the way the declaration was adopted, and we should not underestimate that the declaration was one of the very few instruments in international law that came out from the actual people that the declaration concerned. So it has a different weight, it has different legitimacy, because indigenous communities took part in this process. So it is not a mere declaration. It is, it was from the very beginning something kind of very powerful, and that's why something very powerful and something that and an instrument that states were convinced had to be adopted. So the indigenous communities convinced them that they really needed an instrument to protect their rights. So that's why I think so many UN human rights instruments and also regional instruments and regional kind of bodies such as the Inter-American Court of Human Rights refer to the principles established in the Declaration and in some cases in the Declaration itself. So it is very powerful, and I think it is. I think that with the war on terrorism, the rights of specific sections of the population started being restricted, and states started being very reluctant to talk about human rights. So we started talking a lot about national security again, and we started being a bit, we started regressing, a bit when it comes to the other, and we started seeing, international community started seeing the other as a threat again. And I think that this was not the case with indigenous peoples. Indigenous peoples had convinced the governments that as the others, they're not a threat, but they're here to take part in international law and to advance international law and, get their respect for their identities. So I think that's why the international community has been convinced about these, and that's why it keeps referring to indigenous rights, because it is a fresh and a very interesting and a very well needed area of international law. So this is why I think, so many people and so many bodies refer to indigenous rights. Now, customary international law. I think, Leena, from past discussions that I'm very reluctant to use customary international law. And the reason why I'm reluctant to use customary international law is because it is rather fluid. When you have interpretation of the treaty, it may be a bit more clear what you're dealing with. And I think that I am in disagreement on this specific issue with my North American friends and scholars. So they're the ones that are very eager to accept that parts of the declaration are customary international law. And I think that parts of the declaration are customary international law, not the whole declaration, not the declaration as a whole, but I think that issues of consultation and participation, not free, prior and informed consent. It is still an emerging kind of an emerging standard, but when it comes to rights of consultation, the basic right of consultation and participation, I think it is customary international law. The basic right of land rights, kind of use of the lands where Indigenous live and possession of the lands where Indigenous live and ownership of the lands where Indigenous live, or at least, and also management, control and management of the lands where Indigenous peoples live. I think probably, it is customary international law. But not the declaration on its whole. And if I have a treaty, if I have a choice between an article, a provision of the declaration, or an assumption that this provision is customary international law, I am going to use the actual provision.
Mm-hmm. Makes sense. So if Finland decided to ratify the ILO Convention, what would be the major benefits for Sami in that?
I think that clarity. I think that my understanding, and I am not an expert on Sami rights, but my understanding is that Sami do have kind of a good level of rights in Finland. Of course, there are tensions and problems and issues. So I think that it would be really helpful to have clarity when it comes to the rights that they have. And international law gives such clarity in treaties. Finland has always been positive towards the declaration, but the declaration, as we said, is not a treaty, whereas the ILO 169 is a treaty, so there will be a lot of clarity. I think this would be one of the issues. So it would be a clear standards that Finland would have to, minimum standards that Finland would have to always respect and keep in mind and implement. And I think this would be the main contribution.
So thank you, Alexandra, for this very important and wonderful insights coming from such an expert. Very honored to talk with you today.
A real pleasure.
So thank
you.